Madam Justice Epstein was called to the Ontario Bar in 1979. She was appointed Queen's Counsel in 1992. Those of us who have been around for a while who remember Justice Epstein as a very eminent civil litigator in Toronto, latterly with her own firm of Gloria Epstein and Associates. And she left that firm in September 1993 to move on to new challenges when she was appointed to the Ontario Court of Justice General Division. Of course, for those of us in this room, Madam Justice Epstein is best known to us as the trial judge, and less well known to us, I think, but it's emblazoned in her memory as the case management judge of the M versus H case when it was at the trial level. And I'm sure we're all very pleased to recognize that Justice Epstein's courageous and groundbreaking trial decision was sustained both by the Ontario Court of Appeal and this year 8-1 by the Supreme Court of Canada. Madam Justice Gloria Epstein.
I'm going to thank Doug for his very kind remarks in introducing me, except for one thing. I really would have preferred that he not use the word groundbreaking, especially after having just fallen off a horse over the weekend and having broken my clavicle, which doesn't sound like a lot, but a year ago, almost to the day, I fell off my horse and broke my pelvis. So I really am resiling from the whole expression of groundbreaking from here on in. But I will tell you that when I was first asked to speak today, the suggestion was that I trace an odyssey of decisions through the courts that have taken the rights of the gay and lesbian community from pre-1967, when homosexuality was a criminal offense, to my all-time favorite case known as M&H, which is said to have given gays a type of family status. Since most of you are more familiar with that journey than am I, and indeed many of you have played key roles in that journey, I have chosen rather to speak about the import of M&H on 3 levels. The first level is a very personal one, namely what being the trial judge in M&H meant to me. The second is the impact on M&H on the gay and lesbian community, if I may be so bold as to venture a comment. And finally, and more boldly, I propose to say something briefly on what I see as the significance of the decision on our country and on our national identity. As I start with the personal level, I'll confess that I've been warned by someone whose opinion I respect a great deal that I ought not to get too personal, that I should sanitize my remarks somewhat. While the public wants judges who are real people with real issues of their own, this realness shouldn't be too much in your face. As wise as that advice may be, and while I don't propose to stand here and talk about all of my various warts or breaks, there is a personal perspective that I feel is important, at least to me, to share, because it's very much a part of the M&H story. On July the 1st, 1995, my only sister died of breast cancer. We were very close, and while I was fully aware of how ill she was and the inevitability of her fate, I wasn't at all prepared for her death and the effect it would have on me. In a family where I'm often considered the leader, the strong one, the one with the answers, the one who can make things happen, I could do nothing to save my sister. Her death had a profound impact on me, and for a considerable period of time, I fell into the depths of a serious depression. In the middle of this painful time in my life, I heard and decided M&H. In September of 1995, just 2 months after I buried my sister, I spent 3 days hearing the argument in that case. It was several months before I had the strength to tackle the written part of my judgment, although I thought constantly about the case, partly because of its compelling nature and partly as a distraction from my own personal trauma. I released my decision on a cold, bleak Friday in February of 1996 and boarded a plane to Moncton, New Brunswick immediately to visit my son, who was then in first-year university. I had no idea that the decision would make the front page of every major newspaper. I also had no idea that most reports of the case would be quite inaccurate. I was totally unprepared for the very negative reaction of many of my fellow Canadians, including my friends, colleagues, and yes, even some members of my family. I recall attending a fundraising event for breast cancer a short while after the release of my decision and being accosted by people anxious to let me know that they found homosexuality quite abhorrent. My decision, which was interpreted by many as a recognition of homosexual partners as families, and by others, God forbid, as allowing gays and lesbians to marry, was seen as facilitating or even encouraging this sin. I was stunned by the attack that people were prepared to make to my face and by the attack in the press. My reaction to all but the most personal of assaults was always the same. I would advise the concerned individual that I respected the fact that he or she had views of the situation and that they were interested enough to share them with me. I then went on to say that they had to appreciate that I was not in a position to talk about my own views. As the judge hearing the case, I wasn't asked to express my personal opinion of anything. Rather, I was asked to determine facts, apply the law to those facts, and arrive at a legal conclusion. This I did to the best of my ability. Whatever views I had about the result of the case, or where it may take us, were not only irrelevant, but also were views I was not at liberty to share. Such a response overtly accomplished what I intended. It brought any debate that the person in question set out to engage in to a dead stop. That was how I dealt with the attacks on the outside. On the inside, I was particularly vulnerable, and I was hurt by some who felt the best way to attack the decision was to attack the decision maker. I was also hurt by the vast number of people who put no effort whatsoever into understanding the decision beyond what they read in newspaper reports that were, by and large, inaccurate. And it was not just the finding of a violation of Section 15 that wasn't saved by Section 1 that attracted sharp criticism. It was the so-called judicial activism that rubbed those who, in my view, appeared to take a rather restricted view of the mandate set out in the Charter the wrong way. Even those who, at least on the surface, were prepared to acknowledge that I may have been right concerning the reality of the Charter violation, they were completely unprepared to go along with the remedy that I found to be appropriate. I had the audacity to change the law. I must digress a little at this point to confess to you that I'm somewhat stymied as to what exactly constitutes judicial activism. As long as I've been on the bench, I've attempted to decide cases before me, as I did in M&H, by an application of the law to the facts. By and large, judicial activism is, it seems to me, a readily applied catch-all phrase intended to capture every decision that veers outside of some nebulous norm. That's not to say that personal influences do not find their way into a judge's decision. I'll speak to that in a minute, but may I be so bold as to suggest that neither I nor my colleagues have some kind of hidden agenda to change the Canadian legal landscape to one that reflects the values solely of the judiciary. That being said, there is no doubt that the courts have had a larger role to play in monitoring the laws of this country since the advent of the Charter. But that role was thrust upon the judiciary by the incorporation of the Supremacy Clause in the Constitution ratified by our various governments. The irony is worth noting, but the real issue, whether framed as judicial activism or otherwise, is the acceptability of courts striking down laws. Lawyers, political scientists, journalists, and more recently vocal members of the public love to debate the question of whether such action is legitimate. The question arises because under the Charter, the judges, who are neither elected officials nor accountable for their actions, are vested with the power to strike down laws that have been made by the duly elected representatives of the people. Is this a legitimate function in a democratic society? The conventional answer, and the one that I personally find comforting, is that this type of judicial review of laws passed by our elected representatives is legitimate. The reason is based on our commitment to the rule of law. All of our institutions must abide by the rule of law, and judicial review simply requires obedience by the legislature to the law. This takes us to the next level of concern as we get a little deeper into the debate, and that is that the Charter is couched in such broad language that in practice the judges have a great deal of discretion in applying its provisions to laws that come before them. The process, therefore, of applying the Charter inevitably involves interpreting its provisions into the likeness favored by the particular judge, rather than, if I can use a baseball term, saying that we calls them as we sees them. They are what we calls them. And I'll admit that this particular issue, one that inevitably leads to analysis of how our judges are selected, poses some interesting but difficult issues. They will continue to be debated for some time. Personally, in M&H, I took considerable comfort in following the lead of the Chief Justice of the Supreme Court of Canada. In April of 1995, this is what Chief Justice Lemaire had to say, and I quote, "Some people speak as if these new responsibilities under the Charter are simply judges seeking more power. Nothing could be further from the truth. The judiciary did not seek those responsibilities, and we certainly did not assign them to ourselves. They were given to, indeed imposed upon, the judiciary by the politicians. It was a job given to us, either deliberately or by default, by the democratic process. As for the suggestion that judges intrude into the legislative sphere, the truth is that many of the toughest issues we have had to deal with have been left to us by the democratic process. The legislature can duck them, we can't. Think of abortion, euthanasia, same-sex benefits, to name a few. Our job is to decide the cases properly before us to the best of our abilities. We can't say that we're too busy on other things or that the issue is too politically sensitive. We do our duty and we decide. The additional attraction, end quote. The additional attraction to this justification for so-called judicial activism was that it happened to coincide with my own personal views. And yes, in the confines of this room, I'm prepared now, after showing so much restraint after M&H, to share my own personal views, at least on that subject. However, and again, just between you and me, I will confess to having worried a lot after I released M&H as to whether I had gone too far. This worry was heightened by the volatile political landscape during the time that M&H was in the judicial system. You no doubt remember the ill-fated Bill 167, the Equality Rights Statute Amendment Act, which would have eliminated any need for an Ontario court, namely me, as case management judge, to consider the case. The bill's troubled history, including the decision of the government of the day to put it to a free vote at the legislature while attempting to water the reforms down to garner enough support, offered no reassurances that the issue in M&H was one that people were prepared to view with any measure of dispassion. That said, I think the situation was best summed up by Marion Boyd, the Attorney General who introduced Bill 167, when she said after its defeat, "One way or another, this issue is certainly not going to go away for our jurisdiction or for any other jurisdiction in Canada." The reality of the politics involved was brought home in the case itself, when the government position changed with the election of 1995. Originally, the government had supported M. The new government switched sides to argue on behalf of H. It was clear to me that this was one issue from which little guidance could be taken from the elected representatives. But Ms. Boyd was right. The issue had not gone away. It had landed in my court, and I had to deal with it. It was against this background of hurt, disappointment, and trepidation over what I had done that I waited for the decision of the Ontario Court of Appeal. As an aside, I will confess to you that I, at all times, recognized I was nothing more than a speed bump on the way to the Ontario Court of Appeal and perhaps to the Supreme Court of Canada. And I don't think Martha McCarthy is here yet, and she'll want to defend herself against this one, but I will tell you it's a true story. And I knew that counsel saw me as nothing more than a speed bump too, because I was driving to work one day about 2 months before M&H was scheduled to be argued, and I was listening to the radio, and Martha McCarthy was on the radio being interviewed about M&H. So I turned up the volume a little bit, thought maybe I'd learn something, and she was talking about how she planned to argue the case in the Court of Appeal. Well, it was 2 months before she was going to argue the case before me. So I thought maybe I could just eliminate myself from the process and save everybody a lot of aggravation. But anyway, I'll never forget that morning, but I'll also never forget the telephone call I received very early one morning in December of 1997. It was a man whose voice I knew, but in the first haze of the morning, I couldn't immediately recognize. He was telling me how wonderful I was, and even then I couldn't figure out who he was. And it turned out that it was Chief Justice Lesage, and he had read the Globe and Mail that morning, and he called to congratulate me on being upheld by the Ontario Court of Appeal. Now, I was honored and surprised that the Chief Justice had called me. I was even more honored and more surprised that the Court of Appeal had upheld my decision by the courageous duo of Justices Sharon and Doherty. I'll say no more about that. But by then I also knew the case wouldn't stop there. I would never deem to suggest that the Court of Appeal would remotely be likened to a speed bump, but we were still on our way. And the uncertainty loomed again. How would the Supreme Court of Canada see it? Again, I waited, and the whole country waited. And then I heard what we all heard. The Supreme Court of Canada was going to release M&H on Thursday, May the 20th, 1999, 14 months after it had been argued. I prepared myself. Unfortunately, the media attention I got that week was as a result of my so-called Martian case. Now, for those of you who know what I'm talking about, I'll admit that the Martian case was interesting, but I really didn't want to go down in history as the alien specialist. I would have preferred slightly different timing in terms of the Martian case and the release of M&H. But the Martian distraction notwithstanding, for me the release of the Supreme Court of Canada decision was an important milestone. My personal struggle of self-doubt resulting from the attacks during a period when I really felt it was over. I had recovered from the depression with more insight and more strength. Moreover, a decision I firmly believed was the right one had passed the supreme test. Now I turn to the next level, a much more relevant one from the perspective of the gay and lesbian community. And here's where I do plan to spend a minute or two touching on the odyssey of that community. It's been 30 years since the Stonewall Tavern demonstrations in New York and the decriminalization of sexuality in Canada. Those 30 years have seen a number of, and I hate to use the word, victories for the gay and lesbian community in the courts and in the legislatures. I hesitate because I'm not sure that gaining the same rights enjoyed by other citizens as a matter of course should really be classified as a victory. But in consideration of the struggle endured, there is really no word that better describes the result. In this country, decriminalization did little to bring about an end to discriminatory practices. Early attempts to battle discrimination in the courts didn't fare well. For example, the challenge to the Marriage Act in Manitoba in 1974, where despite a lack of legislative definition of what constitutes a marriage, a judge held it to be self-evident that marriage could only occur between a man and a woman. We will see. There were cases brought in Ontario and Saskatchewan where there was outright discrimination on the basis of sexual orientation, unsuccessful because the judiciary was not ready to read sexual orientation into human rights legislation. Perhaps the low water mark was the Supreme Court decision in the Gay Alliance Toward Equality versus the Vancouver Sun. The majority of the court found that the paper had not violated the BC Human Rights Act on the grounds that the newspaper had adopted a position on the subject of homosexuality and that it had the right to refuse to publish material running contrary to those views. As noted by Professor Gerard, this suggested at the time that an honest belief in the immorality of homosexuality would amount to a reasonable cause for a discriminatory act. Those decisions represent the first decade in the courts. Things did improve, but it was largely through the introduction of the charter, which, to quote from Sexual Orientation in Canadian Law, dramatically altered the legal and social context of human rights in Canada. Almost overnight, words like equality and rights became part of the Canadian vocabulary and legal framework. Through the late 1980s and early 1990s, the most profound impact of the Charter was on human rights legislation. Courts either read into the various statutes sexual orientation as a prohibited ground of discrimination, or the legislatures moved to amend the statutes. Perhaps the most important of these decisions was from the Ontario Court of Appeal in Hague versus Canada. It both read sexual orientation into the Canadian Human Rights Code as a prohibited ground of discrimination and identified it as an analogous ground of discrimination under the Charter. The decision of the federal government not to appeal the Hague ruling and the subsequent move to add sexual orientation to the prohibited grounds of discrimination were indeed victories. The road was not without its detours, however. The Alberta Court of Appeal refused to uphold a lower court ruling that sexual orientation should be read into the prohibited grounds in its human rights legislation, holding that the statute, as it existed, neither imposed a burden nor bestowed an advantage to homosexuals, and was therefore neutral and constitutionally acceptable. This, of course, was the Vren decision, which found its way to the Supreme Court of Canada. Vren is one of several recent decisions from the Supreme Court. I'd classify them as landmark decisions on the path to equality for the gay and lesbian community. Mossop, Egan, and M&H being the others that come immediately to mind, and I would add the recent Ontario Court of Appeal decision in Rosenberg. All of these cases, in some manner or another, have advanced the cause of equality appreciably. It is apparent, beginning with Mossop, in which the court laments that the appeal was not taken under the Charter, that the rights of individuals within the gay and lesbian community to be free from discrimination was going to receive consideration from the court under the auspices of the Charter. The lack of a charter argument defeated this purpose in Mossop, but the statements indicated that the court was prepared to examine legislation that discriminated on the basis of sexual orientation. When the charter argument was advanced in the Egan case, the court boldly and perhaps inevitably held that sexual orientation was an analogous ground to those enumerated in Section 15. Even though the ultimate result from a deeply divided court did not favor the plaintiff, you'll recall a 5-4 majority forming because one judge decided that economic concerns allowed the government to achieve equality essentially on an incremental basis, and therefore the objective could be realized over time. The case was a watershed in the cause of equality. Then came the Vren decision. In December 1987, Mr. Vren was employed as a laboratory coordinator by King's College in Edmonton, Alberta. He was given a permanent full-time position in 1988. Throughout his term of employment, he received positive evaluations, salary increases, and promotions for his work performance. On February 20, 1990, in response to an inquiry by the president of the college, Mr. Vren disclosed that he was a homosexual. In early 1991, the Board of Governors of the college adopted a position statement on homosexuality and shortly thereafter, the president of the college requested his resignation. He declined to resign, and on January 28, 1991, his employment was terminated. The sole reason given for his termination was his non-compliance with the policy of the college on homosexual practice. Vren appealed the termination and applied for reinstatement, but was refused. When Vren attempted to file a complaint with the Alberta Human Rights Commission, he was refused because the legislation did not contain a prohibition against discrimination for sexual orientation. The facts are important. More than that, to me, they're somewhat chilling. To those who decry judicial activism, whatever it is, I say that thankfully the Supreme Court was prepared to respond to the obligation thrust upon it to ensure that the right of individuals to be free from unjustifiable discrimination was not trammeled by legislative action or inaction. The court used strong language and condemned the Alberta legislature, stating the process by which the Alberta legislature decided to exclude sexual orientation from the Individual Rights Protection Act was inconsistent with democratic principles. Of course, there were charges, once again, of judicial activism, but I think that the court supplied its own answer to those charges when, in the decision, it adopted the viewpoint that there is no conflict between judicial review and democracy if judges intervene where there are indications that a decision was not reached in accordance with democratic principles. Democracy requires that all citizens be allowed to participate in the democratic process, either directly or through equal consideration by their representatives. Parliamentary sovereignty is a means to this end, not an end in itself. In comparison to the Vancouver Sun decision just 20 years earlier, the Vren decision represented a quantum leap forward. The movement toward the goal of equality by the Supreme Court had not gone unnoticed by the lower courts. In Ontario, a provincial court judge held that lesbians could adopt children. In another decision, Justice Koo of our court held that the definition of spouse in the Insurance Act was unconstitutional. The principles of the Vren decision were applied shortly after its release in the Ontario Court of Appeal case of Rosenberg, to which I just made reference. Though in our system it is impossible for a lower court to overturn a Supreme Court ruling, this decision distinguishes the Egan ratio in such a precise and logical manner that when coupled with the later Vren decision, it's difficult to foresee a situation where economic concerns will ever be argued as a basis for discriminatory treatment in the future. In her characteristically eloquent fashion, Justice Abella in Rosenberg signifies an increasingly prevalent approach by the judiciary in the following words, and I quote, "Differences in cohabitation and gender preferences are a reality to be equitably acknowledged, not an indulgence to be economically penalized." I would put it much less eloquently and perhaps more broadly, and that is, how can we ever put a price tag on equality? And that's something that I just could never understand and never will. It is within this historical framework that MNH came before the Supreme Court. I said a little while ago that I felt that this case represented an even bigger change than the Vren decision, and I'd like to expand upon that now. First, the Vren decision had been foreshadowed by earlier decisions in the lower courts, and it dealt with a legislative exclusion that most provinces and the federal government had moved to correct prior to the decision. Secondly, there was a fundamental difference in the MNH case. At the outset, it involved two individuals, rather than a disadvantaged individual contesting government action. While ultimately it was the Ontario government that took the appeal to the Supreme Court, the case was decided on the basis of the relationship and any entitlement created between the litigants. I think that this distinction, that this is the distinction that permitted the court to reconsider some earlier cases and set out clear guidelines for the future. Guidelines that, in my opinion, will be one of the lasting legacies of MNH. And briefly, they can be summarized as follows. One, a recognition that the relationships between gay and lesbian persons may well be conjugal in nature. Two, a reaffirmation that sexual orientation is an analogous ground under Section 15. Three, a statement that the definition of benefit under Section 15 cannot encompass only the conferral of an economic benefit. It must also include access to a process that could confer an economic benefit. A recognition that a factor of proof which may demonstrate that legislation treats claimants differently is the existence of pre-existing disadvantage, stereotyping, prejudice, or vulnerability experienced by the individual or group at issue. And finally, and perhaps most importantly for the future, an acceptance of the proposition that the societal significance of the benefit conferred by the statute must be considered. For example, will the exclusion of individuals belonging to certain groups have the effect of implying that these individuals are less worthy of recognition and protection? All this complex analysis aside, to me the MNH decision just made sense. I return to the journey and the significance of the decision in MNH to the gay and lesbian community. Just as my personal struggle was fraught with criticism based primarily on prejudice and ignorance. So has the struggle of the gay and lesbian community. I think that the Supreme Court's decision in M&H reflects a leap forward in that struggle, a change in judicial thinking about equality for the community on a why not rather than a why basis. And while I'm sure that the odyssey, not yet over, has helped strengthen the community, it has to be as amazed and saddened as I am to read the following views expressed in published letters and editorials in our national newspapers as recently as within the last few weeks. And I quote, "The denigration of married people is breathtaking. If you call a pig a man, do you ennoble the pig or do you denigrate the man? Calling two lesbian spouses only denigrates those who are truly spouses." National Post, May 1999. And secondly, the Supreme Court ruling to change the definition of spouse did not change my mind even a bit, never will. Homosexual behavior is unnatural, unhealthy, and immoral, and two gays or two lesbians will never be able to impregnate each other and create not even one family on this planet. I hope I got the accent right. Clearly not everyone is ready yet. But then I also read this. Despite assertions by those who oppose equal treatment for same-sex couples and their children, every study done to date knows that children of same-sex couples are just as healthy and just as well adjusted as children of opposite-sex couples. The children who will benefit most from legal recognition of same-sex couples, aside from such couples' children, are young gays and lesbians. Instead of being told that same-sex couples represent no benefit to society, they'll get the message that gays and lesbians are valued members of society, equally worthy of dignity and respect. That's the real message sent by the Supreme Court. And now I turn very briefly to the bigger picture, the national and perhaps international significance of M&H. As I see it, the decision has helped to brighten the beacon that sends an important message to Canadians and to people around the world who may be interested in us either for personal, economic, or political reasons. The message is this: as Canadians, we believe in the inherent worth and dignity of all people. We believe in equality. Now, while this belief itself is critically important, it must be reflected in how our lives are governed and ultimately how we conduct ourselves. And this is where the monitoring role of the courts becomes so important. Simply put, our charter mandates equality of our laws that cannot reasonably be justified. If the elected representatives fail to pass laws that comply with the values enshrined in the charter, either due to political pressures or otherwise, the judiciary not only has the ability but the obligation to rectify this situation. As Justice Iacobucci said in a recent speech, quote, "Where the legislature chooses to enact with full knowledge of constitutional gaps, then the responsibility for initiating constitutional dialogue must shift to the judicial branch. Nor does abdication by the legislature absolve the judiciary of its duty to decide issues of rights and freedoms." The larger significance of the Supreme Court's responding to its obligations to ensure that our laws do in fact reflect the values recognized in the Charter is simply one of confidence. As Canadians, we can be confident that the system is working, or at least starting to work, and that our right to be treated equally under the law has some real meaning, and the world will see this and will respect us for it. But like the struggles to which I have alluded in dealing with the personal level, and that of the gay and lesbian community, the national struggle, while similarly impeded by prejudice and ignorance, is far more complex. But as always, there can be opportunity in adversity. As we address the resistance of those who struggle with the full meaning and consequences of equality, and with the process of attaining it, we as a nation will also gain strength and insight. Thank you.